This morning in Legal Logic, we are talking about a topic that has been all over the news lately. Yes, the legality of confidentiality agreements. And back in studio to break it all down for us is our friend, attorney Brian Kuna. Good morning,
Hey,
Brian.
Brendan. How are you?
I'm good. Welcome back.
Yeah, thank you.
I think we should start right at the beginning here.
Right.
I think a lot of us are tired of hearing the words confidentiality and agreement together all over the news. So first of all, really, what are they?
Yeah, confidentiality agreements or non-disclosure agreements, which is the way they refer to them in the whole Trump thing.
Right.
It's basically an agreement between two parties where they've agreed to some agreement with regard to confidentiality. They're usually used in an employment context, generally between an employer and employee. And employers oftentimes want to keep certain trade secrets, marketing information confidential. The classic example is, remember Big Tobacco? Ever see that movie, The Insider, with Russell Crowe with Big Tobacco, and they revealed all the secrets? He had signed a confidentiality agreement. He said, I'm not going to spill the beans on what's going on with Big Tobacco. You know, we know about nicotine, it causes cancer, research, and so forth. So that's a legitimate, good reason to keep it. If it's legitimate.
Right.
Okay? If it's against public policy, however, for example, is the agreement injurious possibly to public health?
Right.
Is it injurious to certain moral reasons? Then they may not be enforceable. And this is the whole thing with Trump. They're saying, is there really a legitimate agreement between Trump and the porn star? Or is it really against public policy? Does it somehow interfere with the public's right to know? Which is overriding? Is it more important for the public's right to know, or is it more important to keep this agreement private between these two people?
It really seems like quite the murky area, if you will.
Right. And it is a little bit gray. And it's interesting because I'm not sure what's going to happen because it's now before the federal court in California. And one of the provisions in that particular agreement is, it says it's subject to arbitration. And California courts generally, particularly the federal courts, like to keep things out of the court if they possibly can, keep the agreement private between the two people. Of course, what Stormy Daniels' lawyer is trying to say is, nope, we want this out in the public because the public has the right to know about this seamy relationship. Whether it's going to, what happens will be very interesting.
Well, that's, you know, when we see that fine line, if you will, then we say to ourselves, when we see these people appearing on talk shows or whatever, you think, well, why are they even appearing in the first place? They can't say anything. Do they just want their face out there? Do they just want more attention? It leaves us with many more questions than answers.
It really does. And it really boils down to what's more important, protecting the individual agreement between these people, or is it more important for the public's right to know? And it really boils down to, is this agreement somehow illegal or immoral? And does that override the private agreement between Trump and in that particular case? Generally, these agreements are generally pretty good because guess what? You're working for a company and you have trade secrets. It serves a real purpose. In the Trump case,
we got to keep our eyes on this one.
Keep your eyes on the ball.
Thank you, Brian, for breaking it all down for us, sir. We really appreciate it. For more free legal advice from Brian, it's great information. Just be sure to visit our website, roadshow.com, and click on the Legal Logic channel.